Welcome to the Napa Legal Weekly Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director.
And I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. I'm traveling this week, so apologies in advance if my traveling webcam is not at 100% quality, but we're doing the best we can on the road this week. So you're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. We have some really good cases this week we're excited to talk about. So we'll start by covering the recent oral arguments at the U.S. Supreme Court in the case Mahmoud versus Taylor, which we've covered previously about the religious exercise rights of parents involving some opt-out provisions and the educational decisions they can make for their children. Then we're going to turn to an Ohio court case concerning a faith-based nonprofit that lost its government funding over its religious hiring practices. And we'll conclude with a positive update on the settlement of the litigation between the Christian nonprofit Holy Sexuality and the tech company Asana. We covered this one previously as well. That excluded the tech company excluded religious organizations from its otherwise generally available nonprofit discount program. So, really interesting stuff. Couple of hopeful cases. Overall, I think a positive episode. So, let's dive in. And Mary Margaret, the first one's for you.
Well, oral argument season is always exciting for the religious liberty movement and legal junkies in general, but the Mahmoud versus Taylor case presents questions that should be of concern and of relevance to everyone, whether you're a court watcher or not. So, for those who've been listening to the podcast for a while, you probably remember this case. A group of parents in Montgomery County, Maryland, wanted to ask that their children be able to opt out of some highly controversial, fairly activist coursework related to human sexuality. And the basis for the request was that these parents who come from diverse faith backgrounds all had religious concerns with what was being presented, either the substance of what was being presented, or the age at which it was being presented, or the context in which it was presented, or all of the above. So the technical question presented was, do public schools burden parents' religious exercise when they compel school children to participate in instruction on gender and sexuality against their parents' religious convictions and without notice or opportunity to opt out? This is kind of a fun crossover episode because the real issue here, we've talked about the burdens and strict scrutiny. And as you might remember, strict scrutiny really in the religious freedom context is this three-part kind of quest, challenge, test. The first part is there a substantial burden on religion? The second part is, if so, does the government have a compelling interest to impose that burden? And the third part is, if so, is the government's action narrowly tailored to achieve that interest? So I like to put it simply, is there a really good reason and was there no other way? So in this case, in oral arguments, the justices really had some interesting dialogue on substantial burden. So there were about four justices who kind of framed the issue of the burden, so how the parents were burdened here, as the controversial kind of indoctrination or exposure of their children to this very questionable kind of graphic portrayals of human sexuality. So they went back and forth on that aspect, and I'll get into that a little bit more later. But then Justice Gorsuch and even Justice Barrett kind of posed the question. There was evidence throughout the case of religious animus towards the parents. At one point, the parents were accused of being xenophobes and white supremacists, which was a very interesting accusation since they were not white um, and still are not. And so some of the justices kind of pose the question of, is being discriminated against itself a substantial burden that would trigger strict scrutiny? So we had kind of four justices focusing on the exposure to the material and at least a couple of justices saying, well, if there was discrimination, isn't that itself a substantial burden? Um, and so just and then we had a couple justices who were, a little bit, I think, hung up on some of the practicalities of this, which you would put into that last question of the narrowly tailored. So breaking it down a little bit, we had Justice Sotomayor and, Justice Jackson really asking questions on the burden as the presence of these books in the classroom, in the mandated instruction of these children who I think were as young as 3, reading these books about, drag, dressing, and kind of graphic sexual stuff. And Justice Sotomayor and Justice Jackson both said, well, is this really coercive? Is this really a burden, a religious burden just being exposed to this material. And then we had Justice Thomas and Justice Alito um, drawing attention to the fact that it wasn't really just books weren't just in the library, but they were actually mandated to be taught. I think it was like multiple times a week during the month of June. Um, and the books also made very significant kind of values judgments, so it wasn't sort of just a neutral portrayal, but it was actually like, here are some skeptical people, they're bad. Here are some people who are embracing this portrayal, this they are good. And so it was more than just exposure in these justices' kind of perspective, or at least kind of their line of questioning. And so all four of those justices really seemed focused on, was there coercion? Was there a burden? And if so, everything kind of flows downstream of that. And then we had Justice Gorsuch and Justice Barrett really looking at Justice Gorsuch in particular, posing the question in the tradition of the Church of the Lakumi, where if you penalize someone specifically because of their religion, and there are even these nasty comments on the record about it, doesn't that automatically triggers strict scrutiny? And he I think mentioned the case Church of the Lakumi, where there was a rule that applied only to people who were doing this particular act for religious reasons. So everyone could do this one thing except for people who were doing it for religious reasons, and they couldn't do it. And so there was this the Supreme Court at that time found there was this negativity toward religion that was impermissible. Um, and then Justice Barrett kind of similarly, kind of went back even further into fundamentals and just said, "Hey, when we're talking about religious exercise, what is the burden?" Um, and then finally, we had Justice Roberts and Justice Kagan, really Chief Justice Roberts and Justice Kagan, kind of focusing on the workability. So the school board had said, "Well, we can't accommodate religious opt-outs," and then Justice Kagan said, what are the limits and where can lines be drawn? And I think there was even some references to the Scopes trial, which is, or Scopes questioning, which is a question of whether like evolution could be, or Darwinism can be presented in a classroom. So certainly some throwbacks and Easter eggs in the oral arguments here. And then just to close, what can we expect? Based on the line of questioning, of course, we never know, but it does seem like there might be a potential for a narrow ruling. Even the justices who seemed kind of favorable towards the issues here seemed to struggle a little bit with articulating a test that they felt confident in drawing the connecting the dots to this important case Yoder, which was really one of the threshold cases on a parent's religious right to educate their children. So I think the concerns almost on the practical line drawing really seemed to limit the court's exploration of the issue. And then the other thing that I think will be useful, regardless of whether this is a narrow or broad ruling, I think we'll get some additional clarity on the burden kind of factor in strict scrutiny for exercise cases. So, um, no matter kind of where the court lands on its holding, I think we'll see some commentary and some analysis on whether discrimination per se is a substantial burden, and whether that was present here. And then additionally, where is the line between sort of a passive exposure and an indoctrination, and when does that become a religious burden? So this was a fascinating case. It was a fascinating oral argument. It went a very different direction than I expected. And yeah, I hope that we see some great wins for parental rights, and some continued kind of connecting of the dots between parents' rights, religious freedom, and the public education and the related regulations. So, Frank, I would love to hear your thoughts on this case, where what we might expect, and most importantly, why it matters.
Yeah, just you did a that was a great overview to summarize that thorough of an oral argument that quickly. That I think you hit the highlights. Just two things I want to quickly point out. One, I think I can speak a lot more freely not being a Supreme Court justice, so I don't have to be quite as guarded. But you could see hints at this, right? The content matters, right? We're not talking about, and you mentioned this a little bit, but these are not like very basic questions of anatomy and physiology and introductions to sexuality, which I would still argue are inappropriate for elementary school children at all. But like some of this stuff is so graphic that I don't even want to talk about it like on a podcast for adults. And the Supreme Court justices were getting at this. There was an exchange between, was it Justice Alito and the Montgomery County attorney? I don't remember which of the justices, but over like descriptions of sex toys and objects, like stuff like I said, I'm uncomfortable talking about. And so I think that's relevant though, because like you said, that if there's a strict scrutiny argument, like what is the compelling interest in the school exposing children to this? Because we're not the kind of content that we're talking about matters greatly, right? Like there's an argument that no sexual education is proper for elementary school kids, but then even putting that aside, like there's a spectrum between like very tame basic facts of life and like what was discussed at these oral arguments. And I find it kind of shocking. And I'm kind of glad to see everybody being made uncomfortable and having to discuss it in the US Supreme Court, because I think it just draws attention to how inappropriate this stuff is in a classroom for young children when adults don't even want to talk about it. So that's one thing. And again, that's not just like a hot take. I think that does come into the whole compelling interest analysis. I think it's much harder to make the compelling interest case for something that is so far outside of the basic facts kind of education. Um, the other thing I'll say that struck me, there was a little clip from the an exchange between Justice Kavanaugh and the attorney for Montgomery County, which I think is very telling. And again, I don't use oral argument questioning to predict how a case is going to be decided, but I think it is kind of telling that Justice Kavanaugh, and I'm paraphrasing, I don't have the exact quote written down, but basically challenged the Montgomery County attorney and said, I mean, when we're doing these kind of cases of like, government action and laws and then religious exemptions, aren't we kind of looking for the win-win? I think that might have been the term he used, but it was like a very light, like, aren't we looking for the happy medium of like making both? And he said, isn't the opt-out provision exactly that, right? Like the fact that when and the Maryland attorney responded and said, well, too many kids were opting out, right? There are like 120 kids in this particular class or grade, I don't remember, and like dozens were opting out and skipping days when they're talking about this stuff. And I think that's interesting because, well, if a lot of people are opting out and it's not just like a few fringe cases, that maybe says something about the curriculum itself and there's a problem there. But also, I think Justice Kavanaugh is hinting at, you had the compromise, you had the thing that would have passed muster, which is, if you're going to teach this stuff, religious liberty, religious exercise under the First Amendment should allow for opt-out provisions. It's not very burdensome. Religious parents can keep their kids home. By taking that away, I think you've crossed the line where I am fairly confident that the court is going to rule that this was a bridge too far. Because again, if people have strongly held religious beliefs that are very valid in the case of very objectionable content, and you're saying no, you cannot opt out by virtue of being a public school student, parents get no say in this. Like, I'm fairly confident that this is going to go the right way. Like you said, it'll be interesting to see how they draw the line and create the test, but big picture, I'm pretty hopeful on this one.
It's interesting you point out the compelling interest, aspect too, because I don't think that was explored as much in oral arguments, and honestly, I think it's because it's such a slam dunk that all the action's kind of on the, is this a burden, to what extent, and when, but, like, the compelling interest, especially now with I can't remember specifically what the case was, but, there was a recent case that said the compelling interest standard is not just that everyone or at some level of abstraction, it has to be a compelling interest that this kid read this book. And there's no way that this is going to pass that standard. And so, in a way, I think that's almost why the justices didn't even waste time on that question.
Yeah, I hope that's right. Any parting shots on Mahmoud before we move on? All right. So now we'll go to Ohio, and this is a really interesting one, and it's the case is not over, but it's in a pretty good place. So I'll try to briefly summarize the facts and stick to a couple of legal and practical points here. So for those who aren't familiar with this case, I believe it started last December. Alliance Defending Freedom filed the lawsuit. The lawsuit's filed by Grace Haven, which is a Christian ministry in Ohio that provides housing and community services for young girls that are rescued from sex trafficking. The organization was recently informed by the local county government that they would no longer be receiving any public funding through this substitute contract system, where these are very common, especially in like foster care service provider things, where the government has a publicly funded program and they contract with private agencies to provide services, housing, foster licensing, and so on. So Ohio provides contracts to organizations that provide these kind of services for rescued victims of sex trafficking, and they refuse to renew the contract with this particular Christian ministry. And the county's reasoning, apparently, for refusing to renew the contract was simply that Grace Haven only hires other Christians who adhere to their religious beliefs. And the county argued that the participating organizations in this program must not prefer co-religionists in order to be eligible for these otherwise publicly available funds. So here we hit a lot of stuff. So I'm going to try to get through it comprehensively but quickly because there are a lot of issues that Napa Legal cares deeply about buried in this case. So where we are now, Alliance Defending Freedom represented Grace Haven, filed in federal district court in Ohio. The federal district court just recently granted a preliminary injunction, which requires the county to continue working with Grace Haven and not cancel the contract while the lawsuit is ongoing. All of our legal listeners will know that that's a good sign that if you win a preliminary injunction, it's because the court thinks you're likely to win on the merits of the whole case. So, not a done deal, but pretty good news. So, the court's opinion, which I'll get back to in more detail, but it states that Grace Haven would face irreparable harm if the county continues to revoke the funding and the assistance, and that in fact, Grace Haven has been unable to provide housing for some children as a result of losing this partnership, this contract with the government. So, quickly, honorable mention for some interesting facts in here. And if you're interested, it's not a very long opinion. The preliminary injunction order is like ten short pages. There's some interesting stuff. So one thing, the court agrees again that Grace Haven's likely to succeed on the merits of the First Amendment claim. The court also notes that they say pretty explicitly the government doesn't have a compelling interest in refusing to renew this contract, and they also point out some shifty maneuvering that the government actually changed its reason for denying the contract. I think after the lawsuit had been filed, it was originally pretty clear from the record that this was about the religious hiring practice that was, the co-religionist hiring made Grace Haven ineligible for this program. I think maybe somebody thought better of that and realized like, hey, we have some First Amendment precedent that's going to be pretty bad here, like Carson v. Macon. We'll talk about that in a second. So then they switched, and apparently the claim was then that the county hadn't actually been using Grace Haven for county placed children in like years, and so it wasn't worth keeping this contract. And the court briefly, but I think powerfully says like, yeah, no, you switched your reasons and you're not getting away with that. This is a problem. So read the opinion. I didn't go too deep, but I did read through the opinion and saw that. I thought that was a pretty interesting fact pattern to highlight, but I'm going to pass on that. And I just want to point out an optics issue here and then a couple of quick legal notes. So first here, the optics are just so bad, right? Like this is not a ministry that's receiving government funds in order to like proselytize, right? To like convert people to a religion. It's not even a particularly like, I mean, it's a religiously motivated organization, which is great. But they're caring for girls who are like at the margins of society. This is a huge problem. Victims of sex trafficking who are rescued have so many physical, material, psychological problems, and like just the existence of these kind of contract programs from the government is an acknowledgement of this is a huge problem. These young women need to be wrapped in so many resources, and so we're going to create social programs that fund, caring, effective organizations to deal with like some of the most marginalized and traumatized members of society, right? So to withhold funding from an organization who's providing these needed services because of a quibble about the religious hiring practices of the organization, I just think optically, like from a media perspective, it comes off as like really cruel and a really bad move here. Um, on the legal level, I hinted at Carson v. Macon. Like, there's a clear problem here, right? And most of the listeners are familiar with this, but Carson v. Macon, the Chief Justice was pretty clear, right? Excluding organizations from generally available public funding programs solely because that organization is religious in character, but that every other similar organization that is not religious in character is allowed to participate. It's a violation of the Free Exercise Clause. We have that pretty clearly from Trinity Lutheran, and then it grows in Espinoza. But Carson v. Macon is really, I think, like the beginning of the end for these kind of discriminatory cases. And I think if Saint Isidore, the Oklahoma charter school versus Drummond case goes the way we think it probably will, we'll get that ruling in a couple months. Then I think that's kind of the nail in the coffin for these kind of discriminatory programs. So just to recap the Carson, some of the reasoning from Carson, right? Chief Justice Roberts writes that the government's anti-establishment interest does not justify excluding groups from an otherwise generally available public benefit because of their religious exercise. That's exactly right. Carson v. Macon makes it pretty clear, right? If a practice doesn't favor and therefore establish one particular religion to the exclusion of others, it's not an establishment clause violation. I will not get tired of saying this on this podcast. So if that exclusion from funding does not violate the Establishment Clause, and you're just excluding religion, but including every other kind of organization, these are likely Free Exercise Clause violations because you're penalizing and separating just religion, and that's a problem under the First Amendment. So I'm glad we're here. I'm glad because this was not the state of First Amendment jurisprudence 10 years ago, but here we are. So these are really important developments. I think they'll continue. I'm just going to say a couple more things on the First Amendment issue. So um, I think the district court granting a preliminary injunction on this in favor of Gracehaven, actually, the first line of the order in the preliminary injunction quotes from Carson and says that the First Amendment protects against indirect coercion or indirect penalties on the free exercise of religion, not just outright prohibitions. So this is exactly what this case is, right? It's a penalty to a religious organization based solely on their free exercise of religion, in this case, in regard to hiring practices. So like this kind of behavior from the county in Ohio is exactly what Carson says does not fly under the free exercise clause. And I'm glad to see that at the lower court level, the precedents are coming down and courts are starting to catch on, right? Governments cannot exclude religious organizations from funding programs that include everyone else, right? I'll try to skip over. I want to hear from you, Mary Margaret, on the First Amendment claim. So, do you have any other thoughts on this? Because I think we're in really good position. And again, I think once Saint Isidore comes down, we'll see where the tide is turning. But what are your thoughts on the First Amendment part?
I was so glad you mentioned the Carson case, and I think this is, in a way, I guess, kind of the natural segue because I feel like after Carson said, "Okay, you can't exclude religious groups because they're religious," after Trinity Lutheran, but then I think sort of at some level, some of the local and state governments were like, "Okay, well, we won't exclude religious groups. We'll just attach strings to the, participation in the program that would exclude religious groups." So it's like, "We're not excluding you because you're religious, we're excluding you because you pray," or sort of like it's sort of like taking other aspects of what it means to be religious and kind of, uh, grabbing people out or knocking people out on a technicality. I think we saw that in Vermont specifically, and I feel like this is sort of uh, another iteration in that same data pattern of like we're not discriminating against you because you're religious, but because you're religious, you'll never qualify for this generally available program. And I think the courts clarified that also backdoor will not work.
Yeah, but that's a great point. I think that's right. Like stage one of you can't blatantly discriminate against religion has been the stage has been set. And now there are like the workarounds are coming and the courts are getting savvy to those. So I think we're in a really interesting place for seeing how these precedents are going to play out and trickle down. I do want to make one more point for the sake of our state law people. And I know we have at least one fairly regular listener from Ohio. So I want to touch on a statutory point, which granted, the court here doesn't touch on this is straight First Amendment violation, preliminary injunction granted for good reason. But I think it's worth highlighting just practically how troubling it is here that Ohio is excluding an organization, right, from this publicly funded program for engaging in religious action that's specifically allowed by Ohio law, right? So not all states have laws that would protect these kind of co-religionist hiring practices, but Ohio explicitly does. So I think that makes it all the more egregious, even if it's not the primary legal claim here, right? It's not just a constitutional issue, but it's to me a kind of ridiculous situation that Ohio. So let me back up. So Ohio employment law, the statute particularly says, right, you can't discriminate in hiring on the basis of all these protected classes, which of course includes religion. But the section of the Ohio statute, it's 4112.02, says this section does not apply to a religious corporation, association, educational institution, or society with respect to the employment of an individual of a particular religion to perform work connected with the carrying on by that religious corporation of its activities. So Ohio specifically says religious organizations are allowed to do this, but then they turn around and say, but if you do this, we're going to pull your funding, right? So I thought it was an irony worth mentioning that it's not just like a fight about the First Amendment. This is penalizing somebody for doing something that their own law allows them to do.
Yes, Frank, that's a particularly like yeah, a point of irony there. And I think it um all of this relates, I think, to a fundamental principle of religious liberty that we've talked about on the podcast, which is one of the most fundamental principles is that in a country that values religious liberty, the answer to the question who decides who runs the church or the faith organization, the response needs to be the faith community or that the church. itself, not the government. And I feel like these cases are answering the questions in the right way, but then penalizing. So you can make your decisions regarding your internal affairs. We'll just penalize you for them, and that's not going to fly. So I'm encouraged. I'm encouraged by the continued clarity we're receiving on those issues. Well, we'll close with a simple and happy ending. So, if you, in one of our past episodes, we discussed how a tech company, Asana, offered discounts to nonprofits as long as they weren't religious. You might be sensing a pattern here. So, ADF filed suit on behalf of a faith based organization called Holy Sexuality, alleging that a policy like Asana's that offers benefits to everyone on an equal basis, except for religious people and organizations, violates California's own UNRRA Civil Rights Act. Asana recently settled with Holy Sexuality, both offering the discount to the organization and removing their discriminatory policy to protect future religious organizations from that same pattern. I think it's worth noting that many of the helpful developments between religious organizations and private corporations have occurred through dialogue, through settlements, rather than through court ordered outcomes. And I think this is really encouraging. I would encourage faith based organizations to learn from this and remain firm and steadfast in your beliefs, and even view kind of back and forth like this with vendors as an opportunity for evangelization, and try to push back on this sort of corporate America misconception that faith is something icky or negative or to be avoided. And I think the J.P. Morgan victory from a few weeks ago, and PepsiCo's recent announcement that they also will be adopting policies that are equal to all, including those of faith, are all encouraging. And I think it's very important to know litigation and legal action is a really important uh, way to resolve disputes. But at the same time, good old fashioned person to person negotiation and conversation is also a key tool in evangelizing not only people's minds, but also their hearts. So, yeah, I would love to hear your thoughts, Frank, on this, and also on kind of that unique space where we have private parties dealing with religious discrimination and that kind of issue.
Yeah, it's kind of interesting because usually when we see non-discrimination laws, either the Civil Rights Act or state equivalents, enforcement actions between private parties, we're usually seeing them, in our view, misused to go beyond the scope of these things. But to me, this is kind of what these things are intended for, right? Like to ensure that you can't, like the original, right? The Civil Rights Act was I mean, there were several reasons for it, but, like, one of the key optics is, like, you can't just have you're a private party, yes, but if you're a restaurant, you can't just have a lunch counter and say black people are not allowed to eat here, right? We've made this public good decision that in the public square, you don't get to just arbitrarily discriminate against people because of important traits. And so I think this is a pretty consistent, application of that same rationale. Like this is exactly what non-discrimination laws properly applied are for, to say, because it's essentially the same thing. Yes, it's an online discount rather than a restaurant or something like visible, but it's the same thing. Everybody can come here. All nonprofits, you're welcome if you do, charitable work, if you do this, if you do that. Oh, except religious, like you're like you had said, the icky people, like you don't get the discount. Everybody else does. So you're singling out this class, in this case, religious people, and saying, well, you're excluded. And so I like seeing these used in a way that I would say is the appropriate way to use them, since they exist, these types of laws. And the other thing practically is just doubling down on what you said. It's really important that we not that religious organizations, religious individuals not take these things lying down. And I would say in this case, Holy Sexuality had every reason to probably just take this, right? Because if I remember correctly, it's been a while since I looked at the original facts, but wasn't I mean, this was like use of an app or something, and like the difference in price is like, oh, 50% off, but it's like $24 instead of 12, right? So Asana's like, okay, well, $12 a month discount. I'm guessing the number, but it was something like that, right? For 10 or $15 a month, is it really going worth, finding an attorney, going to war, making the national press? But these precedents are really important because then other groups will see what you've done, other companies will see that it's not worth picking on religious organizations like this. So I think it's really important to stand up. So really powerful, particularly to see it in a case where Holy Sexuality had every incentive to just back down and not bother. So I guess with that, we'll wrap up. Thank you, as always, for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we'd appreciate it if you support our work. If you like and subscribe the podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening from. So we look forward to joining you next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofits.
Thanks for listening, and God bless.